afternoon and welcome. This is a regular meeting of the Compliance and Amendments Committee that's enrolled for April 15, 2014 at 4 p.m. and beginning at 4:11 p.m. Roll call, please.
On the call of the roll, Member Nee.
Here.
Nee present. Member Grant.
Here.
Grant present. Chair Washburn. Washburn absent.
Okay, in the absence of the chair, Member Grant and I have agreed that I will share the proceedings, which I'm happy to do. Are there any suggested changes to today's agenda?
I have none.
Okay. Mr. Clerk?
Item number 2, adoption of the December 17, 2013.
Excuse me, Mr. Clerk, you had mentioned off microphone there may be a change.
Concerning item number 4 on today's agenda, file number 13060, it is my, I have been informed that Mr. Littlejohn has received all the information he required, and then I don't believe there is any dispute over that item at this time.
Okay, is Mr. Littlejohn here?
He is not present.
Okay, but he is the one who informed you.
Mr. Werwick, I believe, is the representative from the medical examiner.
Okay, did Mr. Littlejohn inform you that that he has received all his requested documents?
He has not.
Okay, in that case, what I will do is wait. Did Mr. Littlejohn indicate one way or the other whether he plans to attend today's meeting?
He did not. We do have an issue with Mr. Littlejohn in that he only has a mailing address.
Mm-hmm.
His phone number and email address do not function.
Okay.
So he was informed by U.S. mail of today's meeting.
Okay. What I will suggest then is that we do take this matter out of order with perhaps a motion to continue. Member Grant?
I move that we take this item out of order, adding to item number 1. You want to move it all the way to the top?
Moving item number 4
4
to just under item number 1.
Okay. I move that we take item number 4, file number 13060, out of order and move it to item number 2.
Second. Is there any public discussion on the agenda change? Seeing none, public comment is closed. Is there comment by the task force or by the committee? Seeing none, roll call, please.
This is the motion to continue item number 4, file number 130.
Correction. Just to move it up.
This is the motion to take item number 4 out of order after item number 1. On that motion, Member Nee?
Aye.
Nee, aye. Member Grant?
Aye.
Grant, aye. Chair Washburn?
Aye.
Washburn, aye. The motion to change the order of the agenda has passed.
Okay, and Chair Washburn has joined us, so I will relinquish the gavel.
Okay, if you give me a moment here. I apologize for being late. The 47 was delayed and delayed and delayed.
What else is new?
I know.
Okay, so we are now on item 4.
Item 4. Mr. Young, would you call item 4?
Item
please?
number 4, file number 13060, hearing on the status of the order of determination. Larry Littlejohn against Amy Hart, Office of the Medical Examiner, for violating Sunshine Ordinance Section 67.21b by failing to provide access to public records in a timely manner in a response to requests made on August 27, 2013.
Is the complainant here?
The complainant is not here. The representative from the Medical Examiner is here, and the Medical Examiner representative has stated that he has worked with Mr. Littlejohn and provided all the documents that he had requested. But if you would like to call him.
Yes, if you would, please. The respondent in this matter. Could you introduce yourself and then bring us up to date?
I'm Christopher Warwick, Acting Medical Examiner's Administrator from the Office of the Chief Medical Examiner. It was called to our attention that Mr. Littlejohn requested documentation from cases that were from 1973 and onward. They were a span of years. Mr. Littlejohn did not know who the decedent's name was, and he was unaware of the date or time of death. So what we've done is we've made the cases available for him by year. After our meeting in March, Mr. Littlejohn and I actually scheduled a meeting for him to come by the office. We made all the records available. He wanted to see 1973 cases. Those were all pulled. We accommodated him. He had some concerns about the location of where they needed to be reviewed. So the staff made the documentation available in a different area for Mr. Littlejohn. He did have to cancel that meeting due to circumstances that were beyond his control. So what we did was we set up a new meeting, and that occurred on Monday, March 10th. He suggested that 11 o'clock would be a good time. He was there for 23 minutes, and he informed my investigator that he had everything that he needed, and he left. I proceeded to contact Mr. Littlejohn that afternoon, and I got a busy signal. And then later that week, I wanted to follow up to see if there were any other cases, any other years that I needed to pull and make available for him. And it was at that time that his phone number was disconnected, and it's since then that I have had no contact with him since.
Okay. Do the members have any questions?
I have none. Madam Chair, out of courtesy to members of the public, you might ask if there are any members of the public who have facts and evidence to support either side.
Okay. Is there anyone here with facts or evidence to support either the complainant, Mr. Littlejohn, or the respondent? Okay, seeing none. Members have no questions? Okay.
No, thank you so much for following up with that request that we made at the task force.
Not a problem.
Well, at this time, you have an opportunity to state anything else you'd like to.
No, I think our last meeting we covered the request, and like today, this is all the information that I have available. If the complainant was here, we would have, I think, greater dialogue. But at this moment in time, it's my understanding that he has received everything that has met, and it's met his needs. So, but he still has my contact information, and we've made ourselves available, as we will continue to do so.
Okay, thank you very much.
Very good.
Thank you.
So,
Madam Chair,
Member Nee?
move to continue this matter to the call of the chair.
Second. I forgot.
Okay. Is there public comment on this motion to continue?
Good afternoon, Thomas Piccarello. Yeah, I'm in favor of the motion to continue the matter. I'm curious how, if Mr. Littlejohn didn't have a telephone or email, how he was advised of this hearing. If it was by mail, would he even have the mail knowing that there was a hearing today? So, yes, I support the motion to continue the matter. Thank you.
Yeah, actually, I was going to ask our clerk, Mr. Young, how did you attempt to reach him, and how did that go?
Just going further back, when I did schedule this for the Sunshine Ordinance Task Force, his phone number was not working at that time either. I notified him by U.S. mail at that time, and he did appear for the meeting. And I also informed him by U.S. mail for notifying him of this meeting. So my assumption is that he did receive the U.S. mail. Mm-hmm. And in the notice for this meeting, we do state that he is invited but not required to attend.
Madam Chair?
Okay, Member Nee?
Yes, through the chair, Mr. Young, when you sent the mail notice through the Postal Service, you said you assume he received it. Did you send it just straight first class, or did you send it registered or certified? And did you send it in a manner that would enable you to ascertain whether Mr. Littlejohn received it.
It was sent via regular U.S. mail. I make the assumption that he received it, in that he received the first notice at the same address.
Well, I'm a little uncomfortable with that, particularly with the way the Postal Service has been cut back, the way mails increasingly get lost, with deliveries, delivery systems constantly cut. I'm a little uncomfortable with sending a piece of mail like that, which does involve official city business, does involve official business of the task force, and is time sensitive. I'm a little uncomfortable with just sending it first class mail, and I think that in the future, when you are sending mail to a party in interest, it would be a good idea to send it registered or certified, or in whatever manner you will receive confirmation of receipt by the intended recipient.
We can look into this matter.
Thank you.
I guess Mr. Young, I would add that I think in cases, maybe not in cases in general, if you have other ways of contacting the person that seemed to work, email in particular, then...
in general, we do use email to notify applicants, complainants of the meeting.
But he didn't.
But he didn't have,
He
no,
does
he
not
didn't
have
have
that
one. But
email, yes.
so in cases like this where the only way is through the mail, I would agree with Member Nee that the thing to do in matters like this is to do everything possible to ensure that the individual receives a notification of a meeting.
Yes.
Okay.
I will look into a methodology.
Okay, thank you very much. Mr. Hartz, you have a comment?
Ray Hartz, Director, San Francisco Open Government, and I would support the motion to continue also. I recently, as you heard at the last full meeting, was blindsided by a referral from the full task force to the Ethics Commission, which was done on the 3rd of March, and they announced the hearing on the 5th of March, the day that I had already left the state, to be held on the 24th of March, the day before I returned to the state. And I think it's really egregious for anybody to have a hearing on a subject which involves two parties, and do so without one of the parties present, not even asking why they're not there. And that's exactly what the Ethics Commission did. The only comment that was made was by Mr. St. Croix saying that I had not asked for a continuance. Well, the bottom line is I didn't know this was going on. And I think especially the two longest serving members on this body know the history of the Ethics Commission on the length of time it normally takes for a referral to be scheduled. And mine was sent to them on the 3rd and scheduled on the 5th. 2 days. And it was just the afternoon that I had left and was on the East Coast of the United States. And just conveniently enough so they could hold the hearing the day before I got back. So, and what really strikes me as odd is not one member of the Ethics Commission, knowing my vociferous character, had a question as to why isn't one of the other parties here? Didn't even bother to ask. Just went ahead and held the hearing. The one good thing that did work out is Mr. Herrera told the same lies to the Ethics Commission that he told to the Sunshine Task Force, which they didn't accept and found him in violation, and then referred it to the Ethics Commission. So there was a partially good outcome for that. But again, holding a hearing when you're not sure whether one of the parties was made aware of the fact that the hearing was being held does not burnish anyone's image as being a fair hearing body.
Thank you. Are there any additional comments on this matter? Okay, seeing none, Mr. Young, would you call the roll, please?
On the motion to continue the item to the call of the chair, Member Nee.
Aye.
Nee, aye. Member Grant.
Aye.
Grant, aye. Member Washburn.
Aye.
Washburn, aye. The motion passes.
All right. Mr. Young, would you call the next item on the agenda, please?
Item number 2, adoption of the December 17, 2013 regular meeting minutes.
Do I have a motion? Or
Move to approve the minutes of December 17, 2013.
Second?
any discussion? I have one question. On page 2 of the minutes, page 5 of the packet, item number 6. So this meeting was December 17th, and it says that I canceled the January 21st meeting, and I was wondering, I know that meeting was canceled but I'm wondering, did I announce it at that meeting?
My understanding is that, yes, we did. We knew there were no pending items, and there was no meeting of the Sunshine Ordinance Task Force for the beginning of January.
Right. Okay, now I recall.
Yes, so we announced the cancellation of the meeting.
Okay, all right, thank you. Members, do you have any?
No. I remember that.
Member Nee? Okay.
Public comment?
Public comment on the motion to accept the minutes? Okay, seeing none. Mr. Young, would you call the roll, please?
On the motion to adopt the minutes of December 17, 2013, Member Nee.
Aye.
Nee, aye. Member Grant.
Aye.
Grant, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes. Item number 3, file number 13027, hearing on the status of the order of determination, Ray Hartz Jr. against Paula Jensen, Deputy City Attorney, for violating Sunshine Ordinance Section 6721D and 6721E for failure to immediately order the release of records requested and for failure of a representative to appear before the Sunshine Ordinance Task Force.
Mr. Hartz, you have 5 minutes.
Members of the Compliance and Amendments Committee, Ray Hartz, Director, San Francisco Open Government. I think if you look at all the BS that the city attorney's office has turned in for you to look at, I think it really misses the main point. City librarian Luis Herrera had public records in his possession. I spent a year, including coming to this task force, getting an order of determination, going back to the Compliance Amendments Committee, yada, 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 and he still withheld records month after month after month. And finally, at the point a year came, I put in a petition to the Supervisor of Records, who denied the petition based on the fact that he was still producing records. Well, the bottom line is that that's a failure to recognize the fact that he was ordered to produce them and required by the law to produce them well before that year point. And the bottom line is he continued to produce records the next month, 2 months after that, 3 months after that, and finally, after another year went by, I had to do another petition of records. Now, established fact is that the reason he did not produce the records is he did not want to be found in violation of the law. He was accepting $4,000 or $5,000 a year in gifts from the Friends of the San Francisco Public Library, and then going on and filing statements of economic interest which said he got nothing, under penalty of perjury. And he continued to do so for 2 more years, based on the fact that the city attorney's office, in particular the supervisor of records, refused to do anything at all to get him to produce more records, and seemed to be bent on giving him the benefit of the doubt, saying as long as he's going to give it to you sometime in this lifetime, then it's not the job of the city attorney's office or the supervisor of records to do it. Very frankly, he's still producing records. There are still records he's withheld. It took 2 years to get the one set of records that I had physical proof should exist, and it took him 2 years to finally admit that those records didn't exist, and he didn't have them even though he had a written contract with the Friends saying that he should have them. We went to the FPPC in Sacramento. They found him to have violated for 3 years his statement of economic interest in filing them falsely. He was required to go and file new statements of economic interest. And the bottom line, if you look at it, is that he was doing that from the time he became city librarian, and so continued. There were also 3 additional years before we got him to the FPPC. Now, the idea that the city attorney is not to act as counsel for someone trying to withhold public records, I think, includes the fact of doing nothing when you know that they're withholding the records. At no time during the entire 2-year process did Mr. Luis Herrera raise any objection or justification for withholding records. He did not at one point say one record was withheld because it was a personnel record or something which he could withhold. He simply withheld the records. And he did so to keep himself from being found legally in violation of the law. Now, he abused his position, and he did so with the willing support of the city attorney's office, in particular the supervisor of records, whose only reaction seems to be to public records requests, "It's not our job to do, And that's what the long things you've read, if you've read them in this submission today and all that have gone on previously, it's not our job to do this, it's not our job. Well, what the hell job is it? My assumption is that if I'm a citizen and read this law, it says if I submit a petition to them, they're supposed to tell the body, either turn over the records or we'll figure out a justification as to why they're not disclosable. And in 2 petitions, and let's look at one simple fact. If at the end of 1 year I file a petition and they deny the petition saying that they're giving the records, I think that's denying reality. They were supposed to have given the records 9 or 10 months prior to that. But then if it goes on another year, they continue to erratically produce additional records, and on the second petition, produce more records. It proved your first decision was wrong. I don't see and getting into this stupid argument about, we don't turn down all of them, we just turn down 99.9% of the petitions is nothing but idiocy.
Thank you. Is there anyone here to offer facts and evidence in support of the complainant, Mr. Hartz? Okay, seeing none, the respondent.
Good evening, Gabriel Zitrin, City Attorney's Office, and I'm also here with Deputy City Attorney Paula Jessen, Supervisor of Records. I'd like to begin by answering one question that Mr. Hartz posed, which is, what is the job of the Supervisor of Records under the Sunshine Ordinance? And I'm happy to answer that as follows. The job of the Supervisor of Records is, in those cases where a city department says they have a legal justification to withhold certain records, to make that determination. Is that correct under the law, that they can withhold those records, or is it not? Now, that is in 67.21, I believe it is, description of the job of the Supervisor of Records. Now, it is not the only thing that we do, because even though it's not part of what the Sunshine Ordinance requires us to do, we have found that we can much better serve the public by communicating with departments when it is feasible to try to get things done. Why? In the interests of more openness, in the interests of getting people records, because increasing the likelihood that people will get the records that they're looking for. But if you look at the case of an individual petitioner, whether it's Mr. Hartz, whether it's anybody else, when they request records from a city department, what should be our goal? Would that person, would that petitioner rather come away from that with A, an airtight case that these records were improperly withheld, or B, the records? I mean, we help them to get the records, and the assumption that that is certainly, as I said, although it's not part of what is mandated for our office to do, we conduct discussions with city departments to try to get petitioners, that is, as many of the records that they requested as we can. Now, in the case of the library, there was never a point at which, and despite what Mr. Hart said, there was never a point at which we had any knowledge that the library was intentionally withholding records. It was a long process. We did continually work with them, and that is why, as he said, the sort of, more and more records were released over time, because the process of working with them in order to get those records out was a continuing and ongoing process. And as time went on, more were released. Now, this brings us back to, and this was part of our submission to you, or my submission to you, is that when a city department releases records that were previously requested, from the perspective of a department, the departments seem to feel, without exception, that it would be a lot better for them to produce records that a petitioner is seeking than to see a formal order from the supervisor of records ordering them to do that. It's just not going to look as good. And that's perfectly understandable from their perspective. And as a result, that's what happens, is when somebody knows, we're going to say, you just didn't have a legal justification for producing this. That's part of what comes up in the process of our working with them. You say, look, it doesn't look like this is going your way. We want to express these concerns. Maybe the petitioner raised them. Maybe the petitioner didn't raise them. But in any event, that's what looks like it may happen. And as a result, departments release records to petitioners. And we just don't see, not only do we not see anything wrong with that, that's what this, we're trying to bring about more transparency in city government, and that's one of the ways that we go about getting it. So, and in that eventuality, when the department says, okay, you know what, we don't want to see an order from the city attorney's office saying we violated the law and do this, let's find these records, let's get them these records, that's a good outcome from our perspective. It's a good outcome from the perspective of the Sunshine Ordinance. And it doesn't make a whole lot of sense to turn around and say, well, yes, but in that outcome, there was no official order from the city attorney's office, and therefore the city attorney's office is skewing things in favor of the department. There was no order because the department acted in a way that was more consistent with more transparency. So let's get these records out if we don't have a legal justification for it. So it's kind of strange to highlight that we don't issue an order in a case like that. Because again, it comes down to, when you're the petitioner, what would you rather have? Would you rather have an airtight case that somebody improperly withheld records from you, or would you rather have the records that you requested? Which one of those serves the cause of transparency? Which one of those serves the Sunshine Ordinance? And that was how the process worked in this case. It is also how the process has worked in other cases. All right, thank you.
Is there anyone here to offer facts and evidence of support of the respondent? Okay. Mr. Citron.
Yes. Zitron, ma'am.
Zitron, I'm sorry.
I keep saying I'm going to pass out cards.
It's C-I-T-R-O-N.
I-N.
I-N. Citron, okay. Citron. All right. So I know that you haven't been working for the city attorney's office very long, but Mr. Hart's he worked for a long time trying to get these records. So, and I think, the city attorney supporting a department and getting a member of the public records is a proper thing to do. But when the city department is taking many, many months to do this, then we have a problem, because that's a violation of the Sunshine Ordinance. It is not supposed to take years for somebody to get records. And so we've been hearing cases related to this issue for quite a long time. And no one has said that these records should have been withheld, ever should have been withheld. They're public records, so should have been disclosed. And so I think the frustration we had when this case came before us is there was nobody from city attorney's office to explain to us what in the world happened. Why did this take so very long? And so I think, I read the response prepared for this hearing today, and outlining what the responsibility of the supervisor of records is. It's to determine whether records are public. And in this case, it was determined that the records were public. So I
Well,
So what happened here?
you're right
Why
that
did
this was,
fall apart so badly for so long?
you're right that this was unusually drawn out, this was unusually difficult. And you want to address this? All right. The specific nature of the conversations between the city attorney and the library.
Thank you, Gabriel. Since I dealt with both the 2012 and the 2013
Please identify
position-
yourself.
I'm sorry. Paula Jessen, City Attorney's Office. When, as supervisor of records, we get a petition, the classic situation that 6121D, at least in our view, was intended to cover was a department has located a record and is declining to is located a record but is declining to produce it because they think it's exempt, or in some cases there's miscommunication or it hasn't gotten up to the right level. Something has happened where that there is a record. Let's see, let me just take two steps. First, they locate the record and they think it's exempt. That's a classic situation for our office to look at it and say, did they properly rely on an exemption or not? And in some cases we say they did, in some cases we say they didn't. Where they aren't properly withholding it, then in all the cases we've had so far, the department has disclosed a record once we explained that the exemption they were relying on was not proper. And we've not issued any order because the department was willing to produce it. There's another category of cases where departments, there's miscommunications, there are left hand doesn't know, whatever reason, they haven't done it. In many cases, the department, once we get involved, will do the search, locate the records, produce them, respond. And those matters are settled. It's another category of cases that this it is, and these are requesters who are making extensive requests. They believe the department isn't properly producing all the records that it has. We do not consider those part of 6121D. Our role is not to decide if there was an adequate search. This body can decide those things. Our role is not to decide whether they produced a department late. This body can do that. The full task force can do that. Our role is to decide whether a department has a record that it's not producing. Now, there's clearly some crossover between a claim of inadequate search and a department stonewalling. So to make sure that the department's aware of the request, doing a search, paying attention to it, honoring it as it should, we call the department and we say, we got this petition. This is what he's claiming. What's happening with the request? What are you doing? In those instances where the department indicates, where they give us information, they give us records, they explain, and we have no reason to think that they're not making an effort to comply with the request. If it looks like they are, we consider that beyond the role of the supervisor of records. If you look at the 2012 petition, the answer to the 2012 petition, we set forth the reasons why we concluded that we could not identify any record that the department had located that it wasn't producing and should have. That was in 2012. A year later, in 2013, in connection with this complaint at the task force, the petitioner or the complainant again made a request, and we looked at it again a year later. And at that time, again, I would ask you, if you haven't read, this is a very long response. He makes a number of allegations. We went through each allegation of what they're withholding. Sometimes there was no evidence that he had ever asked for that particular record. He even made a request for it. And we said, if we're wrong, show us the request. If they haven't made it, please make the request. Once he responds, we can look at it as petitioner, as the supervisor of records. Some category of records, they said, when I asked them about it, they said, yes, we'll provide them. So there was nothing to order in either case. In neither case was there a category of records or a record that the department had located and was withholding. So from our view, there was nothing to order, and there was no reason to issue an order granting a petition because there was no evidence that they were withholding anything.
Okay, I think I understand the reasoning and your procedures. So the fact that the library was in fact not making available some records that it later produced was not something you were aware of at the time.
Exactly. In 2012, for the reasons explained in that letter, we try to set forth all of our reasoning. We try to say, these are the reasons we conclude. It looks like we don't find any basis for finding. And there was nothing that we found in discussions with staff that indicated that there was a record that they were withholding. Now, they were still producing, there was still communication, there were still requests, they were still going back and forth. They offered to meet with them again. I mean, these were ongoing discussions, but no, there were I knew of no records, and our office knew of no records that they had and they were withholding.
Okay, sometimes when we're thinking about a case, we try to think what it would be reasonable for a department, types of records it would be reasonable for a department to have. And so, maybe in some cases those records don't even exist, but they ought to exist, proper accounting. And we've found a number of instances citywide where apparently records that good practice would suggest ought to be there just weren't. So do you ever think along those lines? I know the requester is asking for records that, it ought to be, like I'm thinking of DPW. We'll pick on a particular agency. We learned that they weren't issuing work orders for great big projects. And we just found that impossible to believe. Why wouldn't you do that for something that cost $500,000? They just were using word of mouth. So, we just found that incredulous. So we were really pushing and look again. These records have to exist. So do you ever do that, or do you rely on the city agency to say, well, we don't have that sort of thing? Or
we certainly, if there, I can tell you. I can't think of specific instances where I question what, well, no, I guess that's not, I guess I have come up in situations where I did question it, and I guess I would press more. I might honestly not have pressed as much as you do. I can't say for sure, but I will, if there's reason to think it's not true, I'll ask them. I might ask others. I might go in the office and say, does this sound right to you? Is there somebody else who would know? Mm-hmm. A few times that has come up. It's not that often. I haven't come across it that often, to tell you the truth, where there isn't a record that I think should be. I only remember, I think it's only been a few instances, not often.
Okay, all right. Because that's another provision of the Sunshine Ordinance, that the records are to be kept in a professional way.
Yes, and again, that would be your bailiwick and beyond. I mean, what I see my role as and what I'm focused on is, do they have records that they're not producing? And the typical thing is, do they think they have the right to withhold it, and they don't. That's really my energy and my focus when I do this.
Okay, all right, thank you. There are other questions, members? Okay. At this time, Mr. Zittrain, you have 3 minutes for a rebuttal.
So I hope that was enlightening to all of you about sort of the role the office played. Beyond that, there were a great many things that may have arisen under the Sunshine Ordinance, issues that occurred within a city department. But I just, I'm not going to stand up here and address, what the library was or was doing that may or may not have, we, as I said, the city attorney's office was never in possession of information that led us to believe they were deliberately withholding records that they weren't permitted to. And whatever other delays, it sounds like there have been a number of complaints before the full task force against that department rather than us. And I can't speak to them, but they seem to be the focus of this complaint when really they shouldn't be. I was looking more for how is the city attorney's office involved, and I'm trying to address that. But the main focus of the thrust of Mr. Hart's earlier remarks seemed to be about the department rather than our office. Beyond that, I hope you have a better understanding now of what happens, not just in this specific case, but also in a general case of, all right, here is the department, here is what we're trying to get out of them, and here is how we go about trying to get it, and hopefully it yields a good result. It yields a better result for the petitioner than it otherwise would have done. But I'm glad that we were able to have that conversation. I hope that it was helpful to you.
Thank you. Mr. Hart, you have 3 minutes.
I'd ask you to notice that all of the answers that you were given, or almost all of them, were related to generic, in this case we might do that, or in other cases, and not addressing this specific case. In my original request to the library, I included a request for a document called the Framework. And in that document, there was a legal requirement signed by Luis Herrera as the city librarian and Donna Barrow, the executive director of the Friends of the San Francisco Public Library, that they report quarterly to the city librarian as to how much funds they raised in that particular quarter and where the funds went. I put that in the original request. I included it in my complaint before the full task force. It was on that basis that the complaint was sustained and he was found in violation. When I put in the request, the first supervisor request petition, I included that in there. I identified a specific document that should have been there. And it was just not answered. And instead of, I don't think that, honestly, the city supervisor of records went to the department and say, are you withholding anything? They went there and said, what have you given him, and what case can we make to show that you're trying to cooperate? Well, the bottom line is, at a year, they denied the petition. Now, if I am in an office where I'm responsible for seeing that something's done, and I get somebody who says it isn't being done, and I deny that they're right, and then it subsequently turns out that the person was right, and the documents were withheld and continue to be withheld, I would have to honestly go back and say I screwed up. But they don't seem to want to do that. They want to say, well, we did this and we did that, and it's not our job, and this isn't it. But the bottom line is Mr. Herrera withheld documents that he had in his possession, all of which were public records, disclosable under CPRA and the Sunshine Ordinance. He withheld them, and most of those documents related to his accepting gifts from the Friends amounting to thousands of dollars a year, and then going and filing statements of economic interest year after year after year, saying he got nothing. And the FPPC fined him and found him in violation. And he did that under perjury. Now, there is no way he could have gotten away with that if the city attorney's office had gone at the time of the first petition and said, look, it's been a year, you still have documents, produce the documents, and if you say there's a reason for withholding it, let's talk about that and discuss it. And I don't think they did any of that. I think they went and said, did you give him his documents? And Mr. Luis Herrera lied and said, yes, I did. And they went, good enough for us.
Thank you. The matter is now with the committee. Member Nee?
Yes, I'm a bit troubled by something that the respondents have said, which is, well, they asked the library, they asked Mr. Herrera if they're providing the documents, and they said, yeah, and well, that's good enough for us. We don't need to issue any kind of order for them to do it. And I kind of have to disagree with that. I think, if that were the case, if the documents were being produced as requested, that would be fine. But the language in Section 67.21D is pretty explicit. It says, upon the determination by the supervisor of records that the record is public, the supervisor of records shall immediately order the custodian of the public record to comply with the person's request. It doesn't give discretion on this. It says shall. doesn't say, well, go to them and ask them if they're doing it. It says shall order. And that's, to me, that's crystal clear. I'm really not sure where to go with this at the moment. I'm still pondering that one, so at this point I'll relinquish the floor if somebody else, if one of my colleagues wishes to comment.
Yeah, in rereading that, I think what I was reading, there was the letter from April 8th from the city attorney's office regarding this matter. What was emphasized was the role of the supervisor of records to make a determination about whether a record was public or not and therefore should be disclosed. And the other part of that 67.21D that states that the supervisor of records shall order that the record be produced, that was not really emphasized. And the impression I'm getting is that the city department is the city attorney will work with the department to help the petitioner get the records. But that's not the same as ordering the department to give the records like now. I mean, the Sunshine Ordinance is, there are a lot of timelines here, and we appreciate the members of the public wanting a timely response. Sometimes it's urgent that the member of the public get the public records sooner rather than later. So it's not enough that the member of the public eventually get the records and you work with the department. The supervisor of records can order, according to the ordinance, can order the department to produce the records. So I don't see that, your role is that the supervisor of records role is very different from our role in that regard. We may at times disagree about whether a record is public or not, or disclosable. We tend to err on the side of, leaning more towards members of the public, or at least the law requires us to. So I think this is an important conversation. It really involves the respective roles of the supervisor of records office and our task force. And I've learned more today about thanks to Ms. Jessen, about the process that's used. But as Ms. Member Nee's reminding us, the supervisor of records has a stronger role than maybe has been used in the past, or definitely in this case. Are there any other comments? Any motions?
Madam Chair.
Member Nee?
Mr. Hart, please. Okay. Since the task force issued its order of determination in your matter, with the city attorney's office and the supervisor of records as respondent, I guess the first question I have is what progress in receiving the requested records from the public library?
Well, there still have been records withheld. We're in the third year now, and I'm still getting records.
Okay.
So,
second question, what, if any, action have you seen from the city attorney's office, from the supervisor of records, in seeing to it that the records you you want, the records you've requested are provided. Has the city attorney's office issued any kind of an order to the public library?
No, and if you actually look through the correspondence I've had with Ms. Jessen by email regarding this matter, both in the first petition and the second petition, I made on multiple times a request that she do issue an order, or that she refer it to some other agency that might enforce it. And nothing was done. Basically, it's just, they'll give you what they'll give you when they'll give it to you.
How can you give us some idea of the voluminousness of the information, of the data that you're requesting?
The total data that I have gotten so far, this voluminous amount, is that high.
Okay.
3 years.
Okay.
And I get a document for 1 year relating to the finances, and then the next year's missing, and the next year's missing, and then I get 3 in a row. So basically it's, well, we have these documents, obviously we produce them every year, but we're only going to give you selected years of them. So it just goes all over the place.
Okay, but you said you received a stack of documents that's yay thick.
Well, what I have gotten so far.
Okay.
Typically what I get is I get 20 pages, and then a month goes by and I get 50 pages.
So would it not be reasonable to assume then that the public library is working with all deliberate speed to get you the records you requested, given given their copious amount?
No, because they made no effort whatsoever until I brought it to the task force and got an order of determination ordering them to do so, and then they started at about 9 months after the original request to produce the documents. And then 3 months went by, I put the thing in the supervisor of records, and they come out with more. Now, if they had come out with the stuff right after the supervisor of records talked to them, we wouldn't be here. But the bottom line, they didn't. And a year later, when I put in another petition, they produced additional documents, which obviously is it's a fact. If I produce documents, these are documents I previously withheld.
Thank you.
Mr. Hartz, I have a question. So would you be able to kind of succinctly identify the records that you are still requesting that you haven't received?
Yes. There are financial dealings between the Public Library, the Library Commission, and the Friends, all having to do with the transportation, hotel accommodations, all those other things. And the library's stance to this point has been there are no communications between the library and the Friends about arranging these trips and paying for hotel accommodations and all this other stuff. And it's kind of like, I asked, and I didn't want to make a joke out of it, but I said, well, so what do? They come back from a trip and they take their receipts and put it in a shoebox in the corner, and then 2 days later they come back and there's an envelope with money in it. How does that happen? How do the trips get arranged? I would like to see the communication from the library asking the Friends to pay for this trip, and the communication back from the Friends saying, yes, we're paying for the trip. Here's the information about the plane flight, the hotel accommodation, and the reservations. And they say there's nothing. No communications at all. And it's impossible to believe that between 2000 and 2013, the Friends of the San Francisco Public Library expended $60 million. And if you look at the records of the Library Commission and the library, they cannot show where any of that money went. $60 million. And this is while Mr. Herrera is getting money from them to essentially, in my point, look the other way.
Thank you. Member Nee?
Madam Chair, yeah. I don't want to drag this out. I think to drag this out further is a bit of an injustice, but I think that under the circumstances, that might be the best solution. What I would like us to see is an instruction from this committee to the supervisor of records to issue an order to Mr. Herrera and the Public Library Department. That order shall instruct the delivery or the access of all remaining requested records, and shall stipulate a deadline by which those records should be furnished, and that the supervisor of records produce by the next meeting, the next meeting of this committee, a copy of that order. It is perhaps a good idea for the supervisor of records to consult with Mr. Hartz on what that deadline should be for the furnishing of the records. But I think that order should be given, it should be in writing, and it should stipulate a deadline. And I guess at this point, my motion, I would make a motion, I move to continue this matter to the next meeting of this committee with an instruction to the supervisor of records to order the public library to furnish all remaining requested records to Mr. Hartz, that order from this supervisor of records will stipulate a deadline, and that if that order is not does not come forth by the time of our next meeting, then I think it would be imperative that we would move forward with a recommendation to send this back to the full task force with a recommendation for referral to the Ethics Commission and or the Board of Supervisors. So my motion is to, sorry to be so long-winded with this. My motion is to continue this matter until the next meeting with an instruction for the supervisor of records to produce, to issue a written instruction to the public library to produce all remaining records requested by Mr. Hartz, and to stipulate a deadline in that instruction.
Do I have a second?
Second?
Mr. Clerk, did you get that was long-winded. Did you get all
Yes,
that?
I do have that.
Okay, thanks.
All right. Is there any public comment on the motion?
Thomas Piccirillo. I find it interesting that the city attorney has the resources to have two deputy city attorneys here today, but not have the resources to provide you with legal counsel. Clearly, you're at a disadvantage. But what's more troubling to me is if you look at the packet, page 12, the city attorney is telling you that you have no jurisdiction regarding determination of the supervisor of records. As already, the task force may disagree, but it has no authority to overrule or modify the determination. So, although I appreciate the motion by Task Force Member Nee, I don't think that Mr. Hartz is going to get his records any quicker, because what the city attorney is telling you is that you have not the ability to tell them what to do. So perhaps you may want to recall either Jepson or Mr. Zitgren and ask them if that's their position. And if they respond in the affirmatively, as they indicated in their statement on page 12, then I think my suggestion is to bring a serious and willful to the full task force. Because what they're telling you in their response is you can't tell them what to do regarding their duties as a supervisor of records. Thank you.
Thank you. Is there any additional public comment on the motion? Seeing none, Mr. Young, would you call the roll on this matter?
On the motion to continue this item to the next meeting of the Compliance and Amendments Committee with instructions to the City Attorney to issue an order to the Public Library to furnish all remaining records and to include in that order a firm deadline on that motion. Member Nee?
Aye.
Nee, aye. Member Grant?
Aye.
Grant, aye. Chair Washburn?
Aye.
Washburn, aye. The motion passes.
Mr. Young, would you call the next item on the agenda, please?
Item number 5, public comment. Members of the public may address the Compliance and Amendments Committee on the matters that are within the Sunshine Ordinance Task Force jurisdiction but not on today's agenda.
Hi. I just want to provide you with more of an update of the Arts Commission. I was so hoping that Paula Jessen would stay, and because she was very frustrated by this situation also. Basically, there are two issues. The minutes are continually late, if they appear at all. Today, for example, all the minutes on all the full commission and subcommittees are completely off their website. I don't know why. I just look at it from time to time, and I note that 20 days have passed and the minutes haven't come up. And that's been a problem that's been going on for well over 5 years. It's nothing new. Even while I've gotten orders against them and they've come and said that they're going to comply, they still don't comply. And then the second one is the most annoying of all, is the immediate disclosure requests, which are just simple things for simple bits of information. One sentence that cannot be answered by Howard Lazar that just grows and grows and grows, includes Paula Jessen. We don't know why, since no petition has been filed. And he just continues to bumble through things. Of the IDRs that I've sent by email, he's probably responded to less than 3% of them, which is a pretty sorry thing there. And it's very frustrating on a lot of people's parts because it's just a waste of everybody's time. Anybody trudging through his nonsense would see that the guy can't even read and write. It's really sad. All right, thank you.
Thank you. Is there additional public comment?
Thomas Piccarello. A couple of matters on your agenda. It's a little confusing to me and maybe other members of the public as to when public comment will be heard. It states that it'll be taken after action is taken on the last hearing item or half hour after the meeting convenes. What does that mean? Whatever comes first? Or it's confusing. Secondly, it seems that the workload after an order of determination is given by the full task force has shifted to the Education and Outreach Committee and away from the Compliance and Amendments Committee. I don't think that's a good idea for a couple of reasons. First, the Education and Outreach Committee is overwhelmed with work. They can't handle what's in front of them. And it seems to me, looking at your agenda tonight or this afternoon, and your last meeting 3 months ago, that was 20 minutes, you could be taking a much greater load regarding orders of determination, getting them enforced, and perhaps then maybe city agencies and city departments would comply with the Sunshine Ordinance. So I would like to see more of a workload by the Complaint and Compliance Committee and less of a load by the Outreach committee that is overwhelmed. Lastly, my recollection is that when Mr. Littlejohn was given an order of determination, there was also another gentleman, Spanish-speaking attorney. There was an order of determination in his favor against the city attorney, the supervisor of records. My question is, why wasn't that matter being heard tonight, this afternoon, in front of this committee? Thank you.
Thank you.
Oh, okay. I'd like to thank Mr. Piccirillo for his comments because I have a concern similar, and the reason I'm addressing it here is because I think that in most cases, order of determination should be sent to the Compliance and Amendments Committee unless it is clearly an educational matter. In other words, if you have a newly hired staff member who doesn't understand the ordinance and you think the best way to handle that is to send it to EOT, I see that as reasonable. What I'm talking about is the sixth hearing regarding the placement of the 150-word summaries, and this one in particular was versus Angela Calvillo. It was a 7-2 vote. The two votes in abstention, voting no, were the chair, Chair Grant, and Mr. Pilpel, who was head of EOT. And then this was sent to EOT, where Mr. Pilpel, as chair, tried to first get it dismissed. And then when the rest of the EOT members wouldn't agree with that, they voted to send a letter to the clerk of the board. 8 months went by where I repeatedly asked, where's the letter? Got no response from Mr. Pilpel, sent 3 requests to the Sunshine Task Force with copies to Chair Grant, asking where the letter was. Didn't get any meaningful response. And bottom line is this letter was never taken care of. I don't think Mr. Pilpel ever intended to write that letter. Now, the reason I'm bringing it up here is because if the purpose of these orders of determination is to get city agencies to follow the law, then sending it to EOT and then undermining the decision of 7 members versus 2 by simply putting this into oblivion, which is what happened, is not right. You know, it's one thing to say, oh, we send things, referrals to the Ethics Commission and they don't support us, but if you send it to your own subcommittees and they don't support the decisions of the full task force, then you've really got a problem. And I'll be honest with you, and I don't know how to say this any other way. I think this was purposeful. Just as last month when I left the city on the 5th, and they announced the referral from the task force regarding Mr. Herrera's decision case, and they announced it the afternoon of the day I left, and held the hearing on the evening of the day before I got back, was not a coincidence. And I don't think this was a coincidence either. The 2 people who voted no on this item simply purposefully, through action and inaction, decided they were going to just make the determination of the task force as a whole moot. And I think that's wrong.
Thank you. Are there any additional comments from members of the public? Seeing none, Mr. Young, would you call the next item on the agenda?
Item number 6, Administrator's Report. I was not going to have a report today, but now we have one item before the Compliance and Amendments Committee concerning the order of determination for Mr. Hartz against Paula Jensen, file number 13027. That's continued to the next meeting of this Compliance and Amendments Committee. And we do have one continued item before the Compliance and Amendments, which is Mr. Littlejohn's item, file number 13060.
All right, thank you. Would you call the next item on the agenda, please, Mr. Young?
Item number 7, announcements, comments, questions, and future agenda items.
Member Nee?
Yes, I received what I consider a piece of very good news today. As some of you might know, the Superior Court ordered the Ethics Commission to provide certain records to Alan Grossman. That decision is under appeal at the State Court of Appeal, and I was informed today that the First Amendment Coalition has filed an amicus brief on Mr. Grossman's behalf.
Do you know when that matter is going to be heard?
No, that I do not.
Okay. So it's moving along. Very good. Any other announcements? Okay. Do I hear a motion to adjourn?
So moved.
Second?
Okay. The meeting is adjourned at 5:20.